Welcome to today's program titled Trade Secrets, Privacy, and eDiscovery, Safeguarding Data in an Uncertain Legal Landscape, the third and final session of our Commercial Litigation Outlook webinar series. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email that you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our moderator for today's program, Rebecca Woods. Rebecca, you may begin.
Thank you, Sadie. Welcome to everybody to this third version of our webinar. This is actually our fifth year doing this commercial litigation forecast. And in it, we ask for our subject matter experts to provide anticipations and thoughts about what will come at you in the coming year. And so this for today, we have three topics for you: trade secrets, eDiscovery, and privacy. And the first person I'm joined here by is Dawn Mertenite, who's here to talk about trade secrets. Dawn is a partner in our trade secrets practice and is based in Boston. Before we jump in on the substance, Dawn, let me just tell all of our listeners that this format is slightly different than your usual webinar. We're not here to just talk, have a bunch of talking heads. Instead, we'll only have two talking heads at a time, and principally me asking my visitors questions in order to pull out a little bit more information. It's designed to be a little bit more engaging, but also a little bit more thought-provoking for you as the listener. So to that end, if you do have any questions or thoughts, please do feel free to drop them in the chat, and I will do my best to raise those in the course of the discussion. So without any more delay, welcome, Dawn, and thank you for bringing your trade secret expertise. The article, I'm going to presume that all the listeners read your article in our forecast, which, by the way, is available on our website. And I think the big headline from your article was that the war on non-competes that was declared by Linda Kahn's FTC last year seems to be questionable in light of the significant change in administrative priorities with our new presidential administration. So what gives? Where are we on enforceability of non-competes under at least the FTC?
Yeah, and first of all, thank you, Rebecca, for having me. I'm excited to talk about this. You're right that last year the big headline was the FTC's non-compete ban, which was supposed to go into effect in September. It was actually almost exactly a year ago that it was issued and published by the FTC. Predictably, we saw a flurry of activity. There were lawsuits filed almost immediately. We came very close to the September 4th deadline before there was a real definitive pause. I think we had a lot of employers in the country who were very nervous about what's going to happen if September 4th, 2024 comes around and we're not ready for this. But in August of last year, a federal judge in Texas issued a nationwide injunction preventing the FTC essentially from enforcing the rule. Shortly after that, a federal judge in Florida issued a similar decision. It wasn't a nationwide injunction, but it did essentially come to the same conclusion that the FTC did not have the authority to opine on non-competes in this way across the various states. Those two decisions were immediately appealed by the FTC, but as you noted, we had a change in administration, which changed things considerably. The chair at the time, Lina Khan, who had been really the driver, the mastermind, so to speak, of the rule banning non-competes, she stepped down in January. And then a commissioner who was already on the FTC, Andrew Ferguson, he became the chair. And that's notable because when he was just a commissioner, he was one of the votes against the rule. So as we all expected, the government said, we're going to take a step back. The appeals had already been filed, as I mentioned, in the Fifth Circuit and the 11th Circuit. And the government about 2 months ago asked both courts to issue a 120-day stay in the litigation as the government decides whether it is going to go forward and defend the rule. all indications are that the government will not pursue the appeals. There was an attempt by a third party to try to essentially step into the shoes of the government, knowing that the government was not pursuing this as a priority anymore, but that was unsuccessful. So most likely this rule is going to be dead on arrival and will never go into effect.
I mean, is there any noise though within either the FTC or administration otherwise? Because while in classical Republican administrations, we would expect this rule to be dead on arrival, this administration with its populist approach seems to be scrambling some things, regulation of tech companies, antitrust. And so, and I'm not particularly educated on trade secret issues, but are there any contrary noises within this administration or even the FTC that might keep a piece of this rule alive?
Yeah, and you're right that it's interesting. We have seen, even in Congress, some Republican lawmakers who have taken up the cause of, whether banning or severely limiting the use of non-competes. So that's a relatively new trend. But with respect to the FTC specifically, one of the really interesting things that I have found in the last few months is the current chair, Andrew Ferguson, who again was opposed to the ban, he has come out and said, we're still going to look at employers who are abusing restrictive covenants, whether it's a non-compete or something lesser, a non-solicit or an NDA. If they're drafted broadly enough, those can be abused by some employers. And so what the chair of the FTC has said is, while I don't think that as a body, we are able to essentially legislate whether non-competes are enforceable or not, we are still going to look into the question of whether certain specific businesses are abusing these agreements. And I don't think there's a huge debate about whether the FTC has the power to do that on an individual basis. The real question had been, can they dictate that non-competes in 99% of cases are unenforceable and unlawful? And that, again, it seems to be clear that the government is taking the position now that no, the FTC doesn't have that authority, but they do have the authority to say, we think company X is misusing and abusing these agreements, and we have the ability to enforce an action against that employer.
Along the lines of bad facts make bad law, I have certainly heard of the existence of non-competes by, say, fast food companies for their fast food employees, which strikes me as so ridiculous that I imagine that the FTC would jump on that. So, I mean, is there a difference in the kind of non-competes that the FTC might find more favorable versus others?
Yeah, I think that's a good example. One thing that, whether it's the FTC or state legislators or state AGs are looking at is, who is the sort of person you are asking to be bound by a non-compete? And if it's somebody who is a minimum wage worker, it's going to be really hard, if not impossible, to enforce a non-compete against that individual. Now, I think what the government, again, whether it's state or federal government, what they are starting to say is, we don't necessarily want to get to a point where a low-wage worker can only avoid their non-compete by essentially calling the employer's bluff and saying, all right, well, I'm going to a competitor, and now you either need to sue me or I'm going to file a declaratory judgment action to try to invalidate my non-compete. And we're seeing more of a focus on the FTC bringing actions against employers that are really using non-competes for every single one of their employees, down to a janitor level or a clerical assistant. That is certainly going to raise issues with the FTC and other authorities. Similarly, if it's not just who is being bound by the non-compete, but the scope of the non-compete. If you have an employee who maybe could legitimately be bound by a narrowly prescribed non-compete, but the employer is issuing an agreement that lasts for years, is nationwide or even worldwide, that might work for a CEO in certain cases, but for somebody who is relatively far down the corporate ladder, that's probably not going to fly.
And while we're talking about these kind of big ideas, when I think about non-competes, I think they operate to serve two purposes. One is to protect, in theory, trade secrets, right? If you have a high-level employee and they necessarily know a lot of the secret sauce of a company to allow them to have them go to a competitor would seem, I guess you trade secrets people call it inevitable disclosure. But then the other function seems to be simply to deprive competitors of workforce availability.
Right.
And I wonder if you can comment on, is one more legitimate than the other, particularly in the eyes of today's administration, if you had to predict?
Yeah, I certainly think if an employer can make a legitimate case that this non-compete is necessary to protect the business's trade secrets, the keys to the castle, that's going to be a stronger argument, whether it's in front of a judge or, somebody on the FTC who's looking into these issues. Now, protection of trade secrets is not the only legitimate business interest that is served by non-competes, and it varies by state, but generally speaking, you can also protect the business's goodwill, including customer goodwill, but it's not enough to show that you're just prohibiting competition. And in fact, judges in particular hate this. You can prevent unfair competition, but you can't prevent regular competition. So the more you can show that this is really the lifeblood of the business that is being protected by this restrictive covenant, the better chance you have of enforcing.
And we've been talking about the FTC so far. I recall that the article talked about the NLRB basically doing a Me Too. So under this new administration, where's the NLRB on, would you predict, on non-competes?
So this one is not quite as nuanced as the FTC. The NLRB, the previous general counsel, had issued a couple of memos in the last few years indicating her position that non-competes violate Section 7 of the National Labor Relations Act. Those memos have been rescinded now that we have a new GC under the Trump administration, and there is no indication that the NLRB is going to be focusing on restrictive covenants at all.
All right. So should businesses feel good in terms of use of non-competes when it comes to at least scrutiny from the federal authorities?
I don't think they should feel great about it. Again, the FTC still has the authority to take action against employers that are, in particular, abusing or misusing these agreements, either with the employees that they're asking to sign or the scope of the agreements. But again, it's certainly a better outlook than we had a year ago when it looked like maybe these agreements are going away completely nationwide, other than in sale of a business context. But then that's only the federal government, right? We also have state legislators and we have judges. And so those two wild cards, so to speak, we have just a patchwork of different rules and opinions across the country. And so it is not the case that an employer can say, whew, all right, the FTC rule is not going to be in effect, I'm good to go.
So tell us what's going on the state level, which in some ways is actually more complicated for employers because there's one federal government to keep track of. There's 50 states and
Right.
other territories. So what's going on and brewing at the state level?
So we have continued to see a ton of legislative activity at the state level. We've really seen that the last 10 to 15 years, but I would say in the last 5 years, it has really ramped up. More recently, the focus has been on the healthcare industry, either in states that might already ban or limit non-competes for physicians. Some of the state legislators are expanding the scope of who is governed by that exemption. And then we're seeing in other states that might not have previously had any sort of rules governing non-competes or other restrictive covenants for healthcare workers, we're seeing, at least on a weekly basis, I would say, a new proposed law, and a lot of those are going into effect. So if we have folks who are in the healthcare industry, that is something that you should absolutely be aware of. It's a fast changing landscape in that industry. We also are continuing to see a lot of focus on so-called low wage non-competes. So again, as I mentioned earlier, a situation where an employer is asking someone who's making minimum wage to sign a non-compete, that's probably going to be challenging, if not impossible, to enforce depending on what state you're in. And even in states where we have seen a wage threshold by legislation years ago, those numbers in many states are continuing to creep up because many of these states have tied the wage threshold to a cost of living increase. So, for example, the Washington State non-compete statute that was effective January 1st, 2020. At the time, the wage threshold was only, I say only, but $100,000. Now it is something like $123,000, just because over the course of 5 years, we've seen the cost of living increase. So that's another thing that employers need to be mindful of and keeping an eye on as those rules change.
Okay. And why is healthcare such a big focus, do you think?
I think part of it is the idea that, much like many lawyers cannot be bound by non-competes unless they're in a business function, the idea that clients or patients should be able to choose who they want to see, whether it's for legal advice or for medical advice. It's not fair to limit. It's really about the patient choice. So legislatures are saying it's not fair to limit a doctor or a nurse as to where they can go once they leave their current hospital system, let's say. And that is going to have downstream impacts on the patient population, which we don't want to see. I also suspect part of it is in the wake of COVID, there's just more of a sense that this is a very challenging job and it comes with a lot of stress. And if a doctor wants to move and continue to see his or her patients, they should be able to do that.
That makes sense. So far you've been talking about state legislative efforts. Your article talks about Delaware, among others, Delaware courts. What's going on over in Delaware?
So I know we don't have a ton of time to talk about this. I could talk about this at length. I think Delaware is so fascinating. As many people probably know, a lot of businesses are incorporated in Delaware. A lot of businesses use Delaware law as their chosen governing law in their contracts, including in their restrictive covenants agreements. And historically, that was fine. And Delaware courts would say, we are a contractarian state. Unless it's something really crazy, if you sign a contract saying you will do X, Y, or Z, we expect that you're going to abide by that promise. That has really changed in the restrictive covenants landscape in the last 5 years. And I think part of it is because the Delaware courts are really clogged right now with litigation on these issues, with parties who really don't have any tie to the state other than the employer being incorporated in Delaware. So what we have seen is, even though there hasn't been a change in the law specifically with the legislature, courts down there are generally saying, we're not going to enforce these as written if we think they are overbroad. It used to be that if the court found that, let's say, the geographic scope was a little too broad, it was nationwide, and we think it'd be more reasonable to have it limited to just the New England states, a court in Delaware could reform the agreement and only enforce it in that geographic scope. Nowadays, it is very rare, if not, I don't think I've actually seen a case in the last 3 years where a Delaware court has done that. Instead, they are really saying, if you drafted this in a manner that is overbroad, I'm not going to do your dirty work for you and limit it. That's on you. And going forward, you need to start drafting your agreements in a reasonable manner. The interesting thing about this is it's not just in the employment context. We are also seeing this in the sale of a business context, which is really surprising because, as you can imagine, in that context, there's often tens of millions of dollars exchanging hands. And even then, there have been cases in Delaware where a vice chancellor has said, I don't care that this was a sale of a business. I don't care that the defendant got $10 million for this sale. This agreement is drafted too broadly, and we're not going to enforce it at all.
Are they applying different rules other than, say, geography and time?
So the things that they look at generally are the time, the geography, and the scope of conduct prohibited. So there's this thing that is somewhat demeaningly referred to as the janitor rule, and it's something that judges, not just in Delaware, but elsewhere, hate. And basically the idea is, if you have an agreement that prevents an employee from joining a competitor in any capacity, including if they were to join a competitor as a janitor, a clerical assistant, something like that, if you have an agreement that would prohibit even that, that is likely going to be unenforceable, because what courts want to see is that the employer is saying, you can't go to a competitor if you're going to be doing the same sort of work for the competitor. And you can't just prohibit someone from accepting employment in a completely non-competitive capacity. So that is one thing that we are seeing frequently in these cases.
Okay. All right, so wrapping up then, in light of the general and increasing hostility to non-competes, what can businesses do to protect their competitive edge?
So I do think we're going to see, especially in states that are banning or severely limiting the ability to impose or enforce a non-compete, we will see more trade secret litigation. We see that in California, where non-competes have been unenforceable in almost all circumstances for many, many decades now. There could be other factors impacting that, but I do think the fact that we see so much litigation, so much trade secret litigation in California is highly dependent on the fact that it's hard, if not impossible, to enforce a non-compete unless you're in the sale of a business context there. So litigation is going to increase. We have seen that judges are holding litigants' feet to the fire, even in trade secret misappropriation cases. And we're going to see a tension, I think, between an employer who's a plaintiff trying to assert a trade secret misappropriation claim, doing enough of an investigation to be able to present to a judge a case where the judge can issue an injunction defining what the trade secret is, because this has been an issue. You can't just say, oh, he took a bunch of files and we think he's going to use our trade secrets. You need to specifically identify the type of information that is at risk. But the other issue is, if you take too long to conduct that investigation and get your papers together, well, then a judge is going to say, you didn't treat this as an emergency. You waited for weeks or months, so I shouldn't treat it as an emergency, and I'm not going to issue an injunction. So there will be a tension there. I think it will be increasingly important for employers to, before the specter of litigation arises at all, really understand what are their trade secrets, who has access to them, what is the value of the trade secret, because that will become a big issue at the end of the day if a case goes to trial and you're trying to prove damages based on misappropriation.
All right, so have a good case and move on it quickly.
Yes.
That's what I'm getting. All right, well, excellent. Thank you, Dawn, for sharing your expertise. Really appreciate it.
Thank you.
Okay, so now we will move on to the third segment of this webinar, and we will talk about eDiscovery. And at some point, the powers that be will give me Jay and Matt. Here you guys are. Welcome. Just when you thought the eDiscovery world was settled, or at least I thought, AI comes along and messes it all up. But here, coming to share their expertise with you from our Chicago office are Jay Carl, our partner, and also chair of our eDiscovery and Information Governance Practice Group, and Matt Kristoff, who is a partner also in the same eDiscovery and Information Governance Group. Okay, so guys, let's jump right into it. When I think of eDiscovery, I think of two different buckets of things. I think first, how do I collect and review the documents that my clients need to produce, and then what I get from the other side in a way that is sensible, that we can do it all smarter, efficient, and faster. And then in a separate bucket, I think about how clients should be running their business and thinking about the exposures that they're creating for the document retention or the lack thereof, and all the stuff, all the work product that they're inadvertently generating that can cause them problems. So let's jump into the first bucket first, okay? So we're going to talk about collection and review of documents. And Jay, before we jump into AI, can you just talk to us a little bit about what we do, we being litigators at large who know what they're doing in terms of review of documents? And so give us the quick lay of the land on the technology, and then we're going to jump into generative AI.
Sure. Well, first, welcome everybody, and thank you, Rebecca. So, in the world of eDiscovery, the introduction of generative AI has been a really a hot topic, a hot button issue. But it's important to kind of understand some context of how we've used technology in the past, right, to defensively review, that is, identify relevant information within the mountains of documents that we collect for litigation, so millions of documents. And for a long time, we've been using what is characterized as a form of AI, and that's machine learning. So this is the predictive coding 1, predictive coding 2, frequently referred to as continuous active learning. And so this is a process of machine learning, whereby documents are reviewed by humans, and then an algorithm works in the background to kind of characterize the text within a document within the coding that is applied by human reviewers, right, to learn from that coding. So it essentially, what it does is it identifies documents based on the coding and ranks those documents and moves them to the top of a queue of the review. So similar to the way that like your Netflix queue works, right? So it'll learn what you like to view and suggest those movies and videos and TV shows to you. The review process works in a very similar way in that it ranks the documents and kind of moves them to the top of the queue. And then what happens is you get through that review, you'll see that there'll be a drop off in terms of the documents that are relevant because it's moving the relevant documents to the front of the queue, and then all of a sudden there's a drop off. And so at that point you ask yourself, well, should I really continue with this review? Because if I've identified the relevant documents, why do I need to review the rest of it? And so at that point, in order to defend the process, we'll do a sampling process to validate the results of that machine learning, to defend the review. And an analysis is done as to whether or not it's proportional within the context of that litigation to continue or stop. And so that's how we've been for years now, litigants have been using, that kind of machine learning AI algorithm in discovery.
So, and I've used that computer-assisted technology, and it's great because my client might send to me, I don't know, 100,000 documents, and we actually wind up only having to review a small portion of that using this technology. So what does generative AI in terms of document review bring to the table?
Matt, do you want to take this?
Sure. So generative AI has a variety of benefits, and as Jane mentioned, we're looking back, there was fear when TAR and CAL were used. We're seeing the exact same thing for these Gen AI platforms. People are hesitant to use them. The adoption rates are relatively low, and there's a few reasons for that. Now, when you're loading these documents into a Gen AI platform, Jade mentioned that CAL learns from your documents, from the coding that you're applying. Gen AI is a little bit different, at least most Gen AI platforms that are in use today. They have an existing model that understands text, understands how to query the prompts that you type in. It understands that into kind of a normalized language and applies it to the documents. It's not actually learning from the content that you have loaded, that you've collected from your custodians, or you've collected from workstations. It's not learning the lexicon of your company or of your documents. It's great at understanding the documents. It's great at figuring out, just a normal way you ask a question. I'm looking for correspondence, natural language to query rather than search terms or some other technologies you might use. But it's important to note that most platforms, because they are not learning from your documents, you have to kind of rearrange and rethink the way that you're going to go about a workflow to identify that responsive materials. Most of these platforms, you would generate a host of different prompts and queries that you are stating, this is what's going to be responsive. Often you can drop in document requests that you get from the other side and maybe provide a little bit of color, but you're describing to the platform, this is what I'm hoping to find. This is what I'd expect. Go out to the population, interpret that, and return that information back to me. So there's different ways that you're applying it. Now, people are afraid of, it can also make those determinations. I found this type of language, or I think that this document is responsive. And so it can make those classifications as to responsiveness similar to continuous active learning, but it's doing it in a different route. Now, some of the things that we can do to protect ourselves, the same validation processes that Jay had mentioned before to kind of take those statistical samples and validate is still critical. It's still important that you do that, but it's a different way. You got to build that in. You have to make sure that you understand the workflow. And that's one of the red flags that we've seen. A lot of vendors that are kind of touting that they have Gen AI implemented into their platforms is when you ask for a workflow or how are you going to validate this? Has anyone at your company actually validated the workflow, the process in a defensible manner? If you get any hesitation whatsoever, work that out before implementing it to the platform. You don't want to be their first case to applying this. So, these tools are fantastic in being able to generate summaries with citations. I think that this document is responsive because of this snippet of text, on the 7th page of this email. And so you can validate not only that those estimates are accurate, but if you need to provide it for depth outlines or other kind of useful test cases, investigations, all of these tools have these beneficial kind of alternatives, different ways to review docs and identify them for use in your case.
Once upon a time, Cal used to be very expensive, and I think now it's free, kind of like the CD player in your car, as it used to be. I'm old. I don't even know what technology is. The streaming platform in your car. Eventually, everything is free. What do these Gen AI eDiscovery platforms cost these days? And are they usable functionally?
They are, with the giant asterisk of it depends on what platform you're using. There's different pricing models we've seen, but still they are a little bit prohibitive. They are an upfront cost typically that you have to apply to your data set. And obviously the larger collection you have where you really want that benefit from these technologies, the steeper the cost. We are seeing a significant drop. As of last year, there's about $1 per document that we were looking at. And that kind of harkens back to what it was back in the TAR and CAL days when that was first rolled out. People are recouping the investment of kind of developing these technologies. We're seeing a steep drop. It's getting closer, less than 50 cents a doc, 25 cents a document. And so it's still a cost, but you also have to think about how that's being charged. We've seen a few different pricing models. One of is each time you run a query, you're getting charged for the documents it's run across. And that can be huge because if you don't get it right away, there's some huge costs right off the bat. So in those instances, we've used samples, kind of target a set to make sure that, this small sample, the responsiveness rates, what it's predicting is accurate. Other models, which are a lot more cost effective, will do one charge across your entire population, and it builds that model based on all the documents you had loaded. And then you can run as many prompts, as many queries across that document set as you want. So, that might be a little bit more upfront cost, but so there's different ways. It's critical that you talk to the vendors that are applying these to make sure that there's no surprise charges. Back in the day with Westlaw and Lexis, where, an associate may spend a couple hours and drum up tens of thousands of dollars in bills. You want some predictability, and you would say, vendor, I'm going to do this, what's it going to cost? And they should be able to provide you a response.
So if I'm a client, I'm probably stuck on, I'm going to want you to use Cal because it's known, it's easy, and its result is a pile of responsive documents and a lot of unreviewed, non-responsive documents, whether I, as the client that gave you or that you got from the other side. What is the benefit? What's the pitch for what Gen AI actually gives me as outside counsel that's better?
I mean, there's a tremendous amount of promise with this technology. So, you can ultimately achieve a very similar result, right, with the Gen AI application in terms of separating piles of documents, right, in terms of responsive documents and those that are likely not responsive, privilege and not privilege. And, depending on, all this is happening right now, and this technology is moving out of development and into production. And so, it'll be interesting to see precisely how it shakes out, but some will say that it will do a much better job at like privilege identification, for instance, right? And there's also, a lot of promise about with regard to like saving time and money with respect to the preparation of privilege logs, for example, right? So it's able to generate natural language in a way that is, the way that you would expect it to be drafted. And so, there are applications of the technology to not only help identify privileged information, but to prepare logs based on, instructions that are provided to the Gen AI platform about rules for creation of that privilege log, right? To save time. Now, I want to stress it still needs to be reviewed, right, by a human to kind of make sure that it is, properly preparing the log, properly identifying privileged information, properly identifying, relevant information. In addition, there can be kind of an interface with the technology to ask it questions, right? So you just kind of, the way that you go about it is completely different than continuous active learning. So you can achieve the same result as continuous active learning in terms of separating the documents, but you might have a particular nuanced issue that you want to explore, right? And so you can start to draft queries and prompts that will tease out that information or help you find information within that document set, or that it doesn't exist, right? If that's what you're looking for, right? So there's a lot of promise outside of just achieving the same result in terms of the separation of piles of documents by continuous active learning. There's a lot of anxiety around it too, though. It is a brand new application of the technology to the problem, and lawyers are conservative, and we want to make sure the outcome is correct.
So we could keep talking about this because I'm hearing also a lot of promise, and I want the promises now, today. But let's move on to my second bucket, which is how do we help clients when they're running their business? Many of them are using Gen AI now, and then they get sued, and we have to start collecting data and producing documents. So what considerations and flags would either of you say businesses should consider while they're using Gen AI?
I mean, it's just, it's exciting. It's exciting technology, and there's so many different applications to it, right? And so our clients and businesses are implementing AI tools in a huge variety of, applications, right? It's as simple as just having, an enterprise level chat interface, just say with like Copilot or ChatGPT to use in everyday business. Maybe there are internal homegrown applications for use in specific business cases. Of course, it can be applied to help identify candidates for employment in the recruiting kind of context. But they all come with a variety of different caveats. Right. And so one of the things that, we've explored in preparing the Outlook article this year is to really think about, information governance issues in the use of generative AI technologies and like record keeping, or even if prompts, Gen AI prompts, its input and the output are not necessarily a record with a capital R that might fall under a company's records retention policy. It's important for the company to really think about how long they're retaining information, like prompt histories, for example, right? And so, Rebecca, as I've worked with you on it in the past, that sometimes in litigation, it's the detailed things that we don't always look at that really make a difference. So, like web browser activity, or when did somebody look at a certain document? What does this metadata tell us? Well, prompt histories are, retained by default oftentimes. And so, companies should be thinking about retention of that. What is the default retention period for that? And if we're going to hold on to it for a while, we should be thinking about how we're going to preserve it within the context of a legal hold, right? So if it exists basically within the organization, based on the wide variety of different kinds of factual circumstances that could come up in litigation, it's quite possible that prompt histories, then that inputs and output of a generative AI could certainly become potentially relevant in litigation, right? So we need to think about retention practices, how long we keep it. We need to think about legal hold, how we're going to preserve it if we need to. How do we extract that information if we're going to need to do that? So, a lot of organizations are scrambling to adopt AI technologies, figuring out how it works in their business. And at the same time, it's important not to lose sight of information governance policies that should, put a wrap around and govern that information as it's created.
Boy, that could really, I can only imagine getting or issuing a document request for your prompt history, because I don't think it's privileged, but in any event, let's move to a different topic. Let's talk about a new version of a very old problem, fake documents. because AI has raised us to the level of Dr. Evil. So we're going to do something fun that take a good look at Matt's and Jay's mugs. And let's go ahead and show this quick video.
On behalf of all of us at Seyfarth Shaw, thank you so much for attending the third Litigation Outlook webinar covering trade secrets, privacy, and eDiscovery, safeguarding data in an uncertain legal landscape.
Okay, so what we just saw was a deep fake, some AI program that Matt used to paste faces on everybody else's faces onto his in video, except for one of them, which was actually your mug. So deep fakes. And in the course of eDiscovery, is this just a salacious headline for clicks and eyeballs, or is this real right now?
Unfortunately not. I've had a couple cases already where there was some incriminating documents and the other side claimed deepfakes. They said, that's not mine, that's not me in that picture. Putting aside the fact that these documents were created 2018, 2017, far before these tools were available to the public, that video took an hour or two of setup to create. And so I just used our firm photos. It wasn't like Jay, Don, and Jason posed for those photos. It was just publicly available information. Creating audio copies takes 15 seconds of audio of someone speaking to generate a believable kind of audio transcription of someone's voice or copy of someone's voice. So we're seeing this, plaintiffs are very often claiming that it's just fake evidence. And they, so we're trying to come up with different ways that we can address this. Not only education of employees, that's critical for them. Most technologies right now, they have that uncanny valley look where you're like, something just feels wrong. I can't tell exactly what it is, but we're seeing that. There's also kind of fraud instances where people are trying to push a deadline very fast, trying to make someone kind of skip over the normal checks and balances they would normally take for transfers of funds or approvals of certain things. Education of employees is critical to avoid, this being an issue. We're seeing experts that are, kind of touting themselves as they can identify deepfakes. They have processes in place. There's a host of different software. It's an arms race, though, with those that are creating the deepfakes versus those that are identifying them. They're getting better and better. It's very rare to see the 14 fingers that we saw last year on someone's hand. Now it's actually pretty good. There's minimal movement, lack of blinking, things along those lines are kind of red flags, but it's going to be a continuing problem, particularly when you're collecting information from personal devices, discrete kind of areas. Organizational ones, you have those audit logs from companies' email servers and things along those lines that you can refute claims of deepfakes. But when you're collecting from personal devices or kind of other sources, it's a little bit more challenging, and you really want to document the metadata. You may have an expert look into that metadata and kind of analyze in a way that you would do, already do for other types of evidence to authenticate it. So it's going to be a much bigger issue, and we're seeing a steep increase in our cases today.
So the dystopian future is upon us.
Yes.
Great.
Yes.
Well, on that calming note, thank you guys, really appreciate it. Much more to come from you all in written and webinar material, no doubt. Thank you. And now we're going to go to our last installation of this webinar, and we will talk about privacy. These are all related topics. So privacy, very important. We're joined by Jason Priebe, who's our firm's Associate General Counsel, and he's our partner, a partner in our also eDiscovery and information governance practice. And he is based here in Atlanta with me. So Jason, on that dystopian thought that we just left, I realize how completely knowable I am to all companies on the planet. What with my car that reports information, my Apple Watch, my Oura Ring, all of the activity I do on social media. And when I talk, many people have this issue, right? You say something, and the next thing you know, you open up your phone and the ads are going like crazy on the thing you just talked about that you need, which some of us play pranks on other friends now, where we talk about something and then, beleaguer them with those ads. So there's this constant war of desire for privacy by humans on the one hand, and yet the highly useful and monetary incentives that companies have on the other hand to gather up all that information and make use of it. So as a general matter for you, where are we currently in terms of privacy protection? And where, this is a big question, and I have some follow-ups for you, but where are we now and where do you anticipate we're going to go, at least in 2025, in terms of privacy protection for individuals?
Well, it's certainly a battle, and as you kind of laid out, between the marketing folks who are very interested in targeted advertising and what they call cross-contextual advertising, which is what you described. You're looking for something, you do a search for cars, and there are some companies who would love to know that you're looking for new cars because they want to market to you about those. Some people may have seen the LinkedIn commercials on TV recently where it's like, hey, don't market this to people who are uninterested. We can help you target your advertisements. And the way they do that is by monitoring what people are doing and building profiles on all of us. The other side of that battle, which is being waged by privacy advocates and honestly state legislators and regulators, is an effort to protect the individual rights and in some places the constitutional right to privacy, in the case of California, and to a lesser degree other places as well. And sort of the balance in between really are the requirements of these laws and regulations, at least domestically in the US and also internationally, for transparency and real informed consent from the individual for what they're signing up for, what they're bargaining for. It's like the old saying, there's no such thing as a free lunch. People are starting to recognize that, as you were saying earlier, things that you might think are free, that, hey, they just come to you free. Nothing's free. Somebody's getting some value for what they're getting. And if you're not paying anything for the product, to quote someone, you are the product.
Right, right. So is there anything happening on the federal level on privacy, or are companies, particularly in-house counsel, are looking to comply with privacy concerns? And we'll talk about their concerns next. But is this all just really happening on the state level?
It is, and it has been for a long time, mainly because of just the failure of the federal government to get into gear with any kind of a uniform kind of federal privacy act. Now, we came somewhat close. Every few years, there's rumblings that something might happen, and I thought our best chance was about maybe 16 months ago, but that sort of withered on the vine. The reason that would be nice, and it's similar to what we saw in Europe with the GDPR, is before there was the GDPR, there was a directive in Europe that essentially instructed each of the European countries to pass their own version of a law that had certain protections in it. And what you had was this confederation, a patchwork quilt of different regulations, and some countries were more strict and others were more lax, and there was sort of infighting about which ones were more business friendly. Well, that's what we're seeing in the United States. We've got various states who are taking it upon themselves to pass their own privacy laws. We have about 20 or more now, and counting. And that's there's no harmony across it, and it's very difficult for a business like a client any client of ours that has a nationwide business to operate, because they have to comply with each of these different rules and requirements. And heck, just the exercise of coming up with a nationwide compliant privacy policy and data subject rights and acknowledgements is a real challenge. And it's not a one-size-fits-all situation.
So many of our listeners are probably in-house lawyers. And their companies probably want to grab as much information as they can, or use pixels, whatever those things are, to track. What are some of the key issue spotting efforts that in-house counsel should make to protect their companies in 2025?
Yeah, and that's something I really wanted to focus on, both in the article and in the presentation today, in terms of stressing the importance of revisiting those external facing privacy policies. We've seen a real explosion in litigation and opportunistic claims by plaintiffs' attorneys for companies who are not arguably as transparent as they could be, that in some situations just simply aren't following the law for their particular jurisdiction, particularly with respect to tracking technologies, the meta pixels, Google Analytics, even that stuff that LinkedIn might be offering on your site. It sounds great from a marketing standpoint that I can share information about my website visitors with LinkedIn, and then they'll give me the business profile, and then I can market to those people. But you got to make sure that you tell people that you're doing that, and you give them the ability to opt out of that, or at least to know what's happening. So the use of tracking technologies like cookies and others has been a real focal point, which really culminated recently in something I would also want to really kind of showcase in today's presentation is a recent decision from the Northern District of California called Shaw versus Capital One, which has created some shockwaves because the decision essentially expanded the claims of someone's claim that there was a data breach under the California privacy law, but it was it went towards the sorts of direct targeted advertising or sharing information with third parties for marketing. Now, the reason this is a sea change is really the way that the CCPA law has been written and the way it has been interpreted for years was that you only got to get to that individual claim for damages under the CCPA if there was a data breach under the traditional understanding of a data breach. So, a bad guy, threat actor, steals your information. It's your personal information, sensitive information, and the company failed to take reasonable safeguards or have reasonable protections for your information, and that that gives you the personal claim and actually under the CCPA statutory damages. So what's changed about the Shaw decision is the judge essentially agreed with the plaintiff's claim that this transmittal of information just about someone's website visits and searches or other things, that's enough to rise to the level of an action under the CCPA, which before had been reserved for a data breach. This has set off a lot of alarm bells because it changed the way a lot of companies were interpreting what they needed to do, or even the downside, the risk of sharing information with third parties, sort of whether it's videos or pictures or just website tracking from cookies.
Is that an outlier? It sounds like a potentially outlier decision by one judge. I mean, is that up for appeal?
Well, it's interesting. It is. It's came through, but I think early March, so not that long ago. There's another sort of foil that's happening with that too, is that the California state legislature is debating, and actually is probably going to pass Senate Bill 690, which exempts businesses who are using website information for a commercial purpose from a lot of these privacy laws and privacy claims. So there is a bit of a counterbalance happening there, but the Shaw case has gotten a lot of traction and a lot of ink, if you will, just because of the notion that it's such a change. Now, the opinion cites some others, California decisions, from say 2020 or 2024, even the MG therapy match case, and where the court concluded that essentially the unauthorized disclosure of personal information is enough if the business failed to take reasonable steps. Now, the question is, just because I didn't tell you I was sharing your information, does that mean I'm not taking reasonable steps to protect your data? And another point that's also probably well taken, Rebecca, is that this is only a ruling on a motion to dismiss the case. The claim is a matter of law. It still is going to go to a jury, so it's still an open question.
Yeah. Okay, so it sounds like companies have considerations of how they stay within the law, whatever the law is for the jurisdiction that their website happens to be pulled up in, And how do you stay out of plaintiffs' target zone? Because we know plaintiffs can be creative. So I think you've kind of touched on the law, but any thoughts on for our listeners, how they might advise their, their internal business partners on how to stay away from trouble from plaintiffs' lawyers?
Yes. And my recommendation is actually to be on the highest of high roads possible, because that if you at least have some clear mechanisms that you have informed notice that you're getting some kind of consent from website visitors, they're not going to have trouble with trying to litigate whether whatever you did was adequate or not. If they're going after the bigger, honestly, companies, and even some medium-sized companies now that have nothing, that don't, or that are doing a web banner or a cookie notice that was compliant, say 5 or 10 years ago, but hasn't been updated. And what I mean by that is, if you would come to me maybe 6 or 8 years ago and asked me, Jason, do I need a cookie banner on my website? And I would have said, if you're an American company dealing with only business in the United States, no, it's not required. Boy, has that changed. Now, I strongly recommend it. Not only that, but because of some of these lawsuits, I also recommend that there be informed disclosures about not only cookies, but other tracking technologies like the things we're talking about. There should be a clear choice to opt into that in order to go to the website, and some kind of an option for people to opt out of cookies and only use what's necessary to function on the website. The other thing that's tripping up a lot of our clients is the timing of that banner, and some of the plaintiffs' firms are also making a lot of hay about the fact that by the time someone sees that banner and gets that choice, the cookies have already fired. You're already tracking my client because they hit the website. And so it doesn't matter if they say no, because you've already got their information. These are things that the plaintiffs are gotten very adept at, just hitting the website with freely available software tools that will show them these things and how it operates. And so it's easy for us to check. So if a client comes to me and wants us to check out their website, we can let them know pretty quickly, and sort of give them a checkup, if you will, and make some recommendations.
Yeah, so it's like a never-ending game.
Certainly is.
Company does X, plaintiffs do Y. Company does P, plaintiffs do Q. So final thoughts, Jason, on where you see domestic privacy regulations headed in 2026.
It's
2025, the rest of 2025 and 2026.
Yeah, so it's just as you described. It's kind of a developing battlefield as we go along. We haven't even talked about the wiretapping claims and the claims that plaintiffs are making, that if I record a call, or if I transmit your chat to someone, to my call center, that's wiretapping. There are claims that's some kind of eavesdropping, and they're making claims under state laws for those. But where things are going really are towards plaintiff lawyers leveraging some of these state privacy laws and restrictions, even on things like the use of AI technology. And honestly, I'd say about 80% of it could be discharged if businesses are more transparent and have better consent mechanisms. Just be crystal clear about what you're doing, what you're collecting, why you're collecting it, and who you're sharing it with. And I think that'll go a long way towards blunting a lot of these claims. What's coming in terms of AI regulations is requirements to disclose and provide an opt-out if you're using AI to do certain types of processing for certain purposes, or collecting sensitive information, which is similar to what you might see for other personal data.
Mm-hmm. Okay, excellent. Well, thank you, Jason, and more to come from you, I'm sure, in the future, because this is busy. Okay, so we finally have the CLE attendance verification form, what you were all here to get, in addition to the brilliance of my colleagues. The code is SS5103. Again, CLE code is SS5103. And I want to thank you for taking the time. I hope you've learned something. Go and read our litigation forecast, and look forward to the next one, because we do this annually. So thank you very much for your time.